Good morning, everyone. Welcome back to our weekly webinar series. Today, we are very happy to say that this is our 75th episode, and it's of course a very important topic when we talk about the Supreme Court judgments, NCLAT judgments, very important judgments for all the stakeholders in the IBC, SARFAESI, and other domains. Over to Anil.
Thank you, Ankit. Namaste to all the participants. We are celebrating today's 75th episode of AAA Weekly Webinar Series. And we are very happy that we have been able to conduct 75 episodes weekly without any gap, and that too continuously. And it is really a pride for us that we could do this. Despite difficulties at some times, despite traveling, we have still been able to do this. So it's basically a celebrations, and it is the love and affection of our audience which keeps motivating us. And we keep devoting time on this research and also delivering the subject. We have also seen that on our YouTube channel, AAA Group, the audience is increasing day by day, and that gives us happiness. We have not monetized it. We are not making any money out of the YouTube. It is only a kind of sharing our knowledge, experience, research with all colleagues, advocates, chartered accountants, lawyers. So this is the objective of our weekly webinar series. It has got no kind of monetary benefit to us, except that it somehow create a credibility that we are trying to do something good for insolvency and bankruptcy court, and also to some extent SARFAESI. So before we start, I will say that today we are sharing with you 4 important judgments of Honorable Supreme Court and some of the important judgments of Honorable Appellate Authority and NCLAT. The 4 judgments that we would be presenting today, one is regarding Custom Department's charge on the assets of the corporate debtor. But this judgment is not under insolvency. This judgment is under the Companies Act. However, winding up under the Companies Act, that is also an issue which is decided in this customs case. And the second is which is a very big litigation area in IBC, whether the belated claim can be accepted. May it be from the Customs Department, may it be from the GST Department, may it be from the State Fair Department, may it be from the Income Tax Department. The belated claims, which actually comes at the fag end of the process, should not be accepted. And in case the RP rejects that, that actually would be appreciable to RP, that the RP has rejected and have not used the power which has not been given to him. And the third is the regarding the liquidator's power. The liquidator has got no right to cancel auction which is rightly conducted as per the process and without placing on record any kind of connivance or cartelization. It is not possible for the liquidator to cancel the auction process. And the last is regarding the limitation law. I mean, as we see, the limitation law is in fact getting more relaxed, and anyone who is challenging the limitation, and we think that most of the areas are covered, and section 18 of the Limitation Act, section 17, 19, in all these sections, it is clarified by Honorable Supreme Court. There are many judgments on Supreme Court, from Supreme Court regarding limitation, and those judgments are now giving way to the financial creditors and to the operational creditors, that they can proceed against a particular corporate debtor even if the debt is as old as 10 years back. Because you see, the financial creditor will find some or the other thing. The financial creditor can find some entries in the balance sheet, audited balance sheet, and then one kind of one-time settlement proposal which is coming from the corporate debtor. And like before the expiry of one limitation period, if there is another acknowledgement, then the period of limitation starts again. If there is another acknowledgement, then the period of limitation starts again. So that way, in the debt would not be even barred by limitation even after 10 years, 15 years. There has to be something to say that the debt was acknowledged. So, Ankit, I'm sharing the PPT. So, friends, I think we can start with the Supreme Court judgments. And as I said, that we'll start with uh, the first judgment, which is the Industrial Development Bank of India, Industrial Development Bank of India, and versus the Customs Department. And this was an honorable Supreme Court judgment where the issue which was discussed in particular judgment by honorable Supreme Court, whether the Customs Act create a first charge overriding the charge in favor of the secured creditor. So the limited issue, because this is actually handling the section 529 and 530 of the Companies Act 1956. In a winding up process, section 529A is a section which provides the waterfall arrangement under the Companies Act, and then the 530 provides a little bit of benefit to the crown debt. So this particular judgment is regarding what exactly is the priority given to the crown debt under section 530 of the Companies Act subsection 1. So that is what we are going to discuss in this particular judgment. So this was a company called 𝒉𝒐𝒏'𝒃𝒍𝒆 Industries Limited. In fact, hypothecated their goods which they imported from Italy in 98-99 and created equitable mortgage on those immovable properties, took a disbursement from the bank, paid to the Italy supplier. The goods were imported and it was kept in a private custom bonded warehouse, and it was packed in 128 wooden containers by executing a bond in terms of 59. And then the bond means that upon payment of custom duty, these goods will be released. Now,
bonded warehouse is a system in customs where the person can import the goods, process those goods within that warehouse, and then re-export it. So basically, export it. So I think that is what is this is. This is a private bonded warehouse. That is what the common terminology for this kind of a system is.
Yes, I think maybe it was private, or it was because the private may have come later,
Yeah,
because this
it's
is
a
something
private
which
bonded.
is
Yeah, it's a
this
private.
maybe even the custom also had the bonded warehouses at that time.
Yeah,
It can be
right.
private or it can be
Or
custom,
it can
both.
be public also. Yes.
Right, right. So the custom department, in fact, in 2000, in fact, they basically passed an order for sale of the warehoused goods. So whatever the capital goods were imported by this 𝒉𝒐𝒏𝒃𝒍𝒆 Industries Limited, and the loan was disbursed by the secured creditors for making payment to the Italy supplier, that particular goods, in fact, the custom started to auction. And in the company, the 𝒉𝒐𝒏𝒃𝒍𝒆 Industries actually went to Honorable Andhra Pradesh Court and admitted the company petition filed for the winding up. In the meantime, the petition for the company was admitted for winding up on maybe some kind of default, and the official liquidator was appointed. And this was basically the application before the Andhra Pradesh High Court single bench was that the custom authority should hand over the possession of imported goods, which actually they are trying to put up on auction on and for payment of custom duty. Now, this application by the official liquidator was allowed. The Andhra Pradesh High Court allowed the application, observing that the custom authorities had not followed the procedure contemplated under the Customs Act before passing the order under Section 72 of the Customs Act, in the absence of which detention order were void ab initio and non-est in the eyes of the law. Secondly, on an order of winding up being passed in terms of Section 456 of the Companies Act, the assets of the company in liquidation by operations of law vest in the liquidator, official liquidator, who alone was entitled to deal with the effects and actionable claims. Now, the Andhra High Court again held that whether the claim of the secured creditor has precedence over the right of the customs authority to recover the custom duty. Now, in this case, IDBI had the right on the goods being a secured creditor. Custom was trying to say that we have an overriding claim on these goods, even if it is pledged to or mortgaged to a secured creditor. And Section 468 of the Companies Act has this is the where the um, company is under winding up. Now, in this case, it has been held for that notwithstanding the winding up order dated 1st of December 2003 in the case of Shri 𝒉𝒐𝒏𝒃𝒍𝒆 and the provisions of 529A and 530 of the company, the custom authorities have the first right to sell the imported goods under the Custom Act and adjust the sale proceeds toward the payment of the custom duty. Aggrieved from this order, ITBI went to the Honorable Supreme Court. Now let us see what is the order of the Supreme Court. The Honorable Supreme Court of India allowed the present appeal and set aside the orders passed by Andhra Pradesh High Court. The sale proceeds deposited in the court and converted into the fixed deposit receipts along with the interest accrued thereon will be paid to the official liquidator and to be distributed to the creditors in accordance with Section 529 capital A of the Companies Act 1956. The very crystallized question in this particular judgment whether the Customs Act creates a first charge overriding the charge in favor of the secured creditor. So in the case, the bench actually examined Section 61, 72, and 142 of the Customs Act, and also examined Section 529A and 530 of the Companies Act, and to consider whether the Customs Act confers any and creates any statutory first charge on the customs dues, and are of the opinion that the section do not incorporate a statutory first charge to override the general law. Now, we'll see what is the general law. And it was held that prior secured creditors are entitled to enforce their charge, notwithstanding the government dues payable under the Customs Act. So the ITBI is an overriding preferential creditor under Section 529 capital A of the Companies Act 1956. And at best, if the requirement of Clause A of Section 530 subsection 1 of the Companies Act are satisfied, the custom dues would fall under Section 530 of the Companies Act and will be categorized as a preferential payment. Now, here is a catch. 529A says the waterfall arrangement. However, Section 530 provides a kind of preferential payment right to Customs Department, being the crown debt. Now, let us understand what exactly is the crown debt. See, Ankit, can you just dwell
Yeah,
on it?
I will just clarify how these sections work. So 529A of the Companies Act 1956 is what we're talking about, because this is an old matter, overrides the other sections and says that the primary payments have to be first made to the towards the people who are towards the wages, outstanding wages of employees, and towards the secured debtors. And the language is very similar to what we have in the waterfall arrangement in IBC. And then we have Section 530. Section 530 talks about a preferential payment. So one is 529A, which talks about payments overriding everything else. 530 then says, subject to 529A, these are the preferential payments that one has to make. In those preferential payments, the first payment, or the clause 1 that has been referred to in this judgment, talks about the payments towards government dues. Then we also have a reference to the Constitution of India in this judgment, where Article 372(1) is referred to. And what is referred to here is something called the Crown Debts Act. Crown Debts Act is part of a common law which was practiced before independence. And since no specific act has perhaps replaced this Crown Debt Act, it has the protection of Article 372(1) of the Constitution of India, which says that if there was any law which was continuing before the Constitution was adopted by India, then that law will continue to be in force. And that's how even that Crown Debt Act, the outstanding dues towards the secured creditors or the preferential rights of the government the crown debts that is called, will override only the unsecured creditors and the ordinary creditors, and it will not override the secured creditors. So this reference must have been used by the advocate for IDBI in this matter to contest that irrespective of what is written in the Companies Act, even the Crown Debts Act never gave a protection to government dues beyond or over and above the secured creditors. And now we see that SARFAESI Act, IBC, and even Constitution of India, Companies Act 1956, they all say that secured creditors will have a primary preference over the liquidation or the value received over and above the government dues.
So, Ankit, you have actually rightly concluded. So, let us understand now the what is the situation of secured creditor. So, there was a rainbow judgment under the IBC, which actually got diluted completely by the Honorable Supreme Court. So, it is basically held now that the GST or the state VAT or the income tax would not have an overriding charge on the secured assets. Now, even the Companies Act 1956, which actually will also travel to 2013 Companies Act, that these secured creditors are secured and they would not be, their rights, their security interest will not be jeopardized by any kind of crown debt. Also, under SARFAESI, the crown debts are completely clear. Like the secured creditor will have their first right, except for the some of the dues of the workmen. So the secured creditors are getting their rights fortified, and under all the laws. So what we are trying to say that it may take some time, but finally the whenever the clarity is achieved, the commercial transactions will move. Otherwise, in case the rights of the secured creditors are jeopardized because of the subsequent demands or subsequent uh, notices from the departments uh, or crown debts, that actually will dilute the credit market of the country. So most of the scenarios is clarified now. The rights of the secured creditors are fortified. So moving on to the next important judgment is RPS Infrastructure Limited versus Mukul Kumar. This is again a latest judgment where it has been held by Honorable Supreme Court that the new credit claims cannot be admitted when resolution plan is approved by Committee of Creditors and is pending before the adjudicating authority for approval. Now, in the facts of the case are that the RPS Infrastructure and KST Infrastructure Cooperator had entered into an agreement for development of land licensed with the applicant. So there were disputes regarding advertisement of the project and arbitration proceedings were initiated. Award was also passed in favor of RPS Infrastructure and an appeal was filed against the award. During the pendency of the appeal, this KST Infrastructure, in fact, was admitted to insolvency. So RPS Infrastructure filed a claim in the insolvency after the like this with a delay of 289 days. At the time of filing the claim, the resolution plan had already been approved and submitted to NCLT for approval. The claim was rejected by the RP on the ground of the delay. Now, the claim is based on a arbitration proceedings were pending. He must have argued that my arbitration proceedings were pending, therefore the claim was not crystallized. When the definition of claims would be seen that even if the claim is not crystallized, even the claim is disputed, there is a everyone has a right to file the claims and the RP will have to admit even the disputed claims. Then there is a delay of 289 days from the CIRP, and it is also not possible that the KST was not, RPS infrastructure was not having the knowledge of the insolvency. Now, let us understand this. RPS Infrastructure filed an application before NCLT seeking directions for admitting the claim. NCLT allowed the application on the ground that the claim should have appeared in the books of account. If the claims had not appeared in the books of account, RP should have a duty to obtain them and verify the financial position. So, therefore, the public announcement may have been missed by RPS Infrastructure. That was the adjudicating authority, and an appeal was filed before NCLAT. And the NCLAT reversed the order of the adjudicating authority. Had actually, they said that the respondent had done proper surveys through public announcement as per IBBA regulation. The respondent had even filed application under section 19 seeking the various records because this record was not available in the books of account. The other records were not given by the management. Section 19 subsection 2 application was filed before the adjudicating authority. The plan was approved by the COC and the resolution plan approved by the COC in case. So NCLAT said that in case the new claims are entertained now, the resolution plan approved by the COC will be jeopardized. Now, let us say what the Supreme Court says. The Supreme Court observed that there was no fault on the part of the respondent. Means the RP has done its duty. It was done as per the records, as per the regulations. Section 19(2) application was also filed. Supreme Court further observed that the public announcement would constitute deemed knowledge on the part of the appellant. The adjudicating authority has not approved the plan. It does not mean that the plan can go back and forth. So the entire judgment is based on one particular eventuality. In case the claim would have been accepted, then it would have resulted in resolution plan going back and forth, back and forth. So there may be one claim is accepted, then there may be another person, then somebody else who might have missed the bus may actually join the bandwagon. That is what is the observation. Let us see the observations of the Honorable Supreme Court in paragraph 20. Honorable Supreme Court says that Section 15 of the IBC and the Regulation 6 of the IBBI regulations mandate a public announcement of the CIRP through newspaper. This would constitute deemed knowledge on the appellant. In any case, their plea of not being aware of the newspaper pronouncement is not one which should be available to the commercial party. Now, when the Honorable Supreme Court is writing which should be available to a commercial party, that actually means that it may be available to workman, it may be available to employee, and it also may be available to a home buyer. It also may be available to a bond or a debenture holder. So the public announcement is available to a commercial party. That's a very, very important significant, that we can't relate this particular judgment with those parties. I think even today, 10 home buyers collectively can go to adjudicating authority saying that the RP is not accepting our claim because it was delayed. I still believe, despite this RPS infrastructure, the adjudicating authority will say and will direct the RP to admit their claim. Similarly for debenture holders, similarly for various other workmen and employees. So where I am coming that this judgment may not be applicable in some of the cases. So my colleagues, my insolvency professionals, they should not keep on rejecting all claims which actually had come after 90 days. So this is because this is a commercial party, and now the commercial party is having some kind of priority, some kind of privileges. The commercial party can look into IBBI website. The commercial party will have employees. However, it may not be known to a workman. It may not be known to a home buyer. So the mere fact, the Supreme Court further observed, the mere fact that the adjudicating authority has yet not approved the plan, and that doesn't imply that the plan can go back and forth, thereby making a CIRP and an unending process. This would result in the reopening of the whole issue. When the reopening of the whole issue, when we say, that actually means particularly as there may be other similar persons who may jump into the bandwagon. As described above in SR Steel, the court cautioned against allowing claims after resolution plan has been accepted by the COC. Now, going to the final observation, which is again very, very important, and the final observation of the Honorable Supreme Court is, we have thus come to a conclusion that NCLAT's impugned judgment cannot be faulted to reopen the chapter at the behest of the applicant. We find it difficult to unleash the hydra-headed monster of undecided claims on the resolution applicant. So the Supreme Court had earlier held, in the case of Swiss Ribbon, I believe, that the hydra-headed monster cannot prevail in the insolvency process. A fresh hydra head will pop up, and the resolution applicant will chop that. So that is something which is not acceptable. So therefore, it has to be a clean slate. Once a resolution plan is accepted, it is implemented. No fresh claims can come and disturb the resolution applicant. Yes, Ankit. We can take up
So
with the limits.
I think we need to differentiate two, three things in this judgment. One, this judgment, the claim came in after the resolution plan was submitted. So that's an important timeline. Now, if the claim would have come before the resolution plan was submitted, then this judgment might have been different. And we have seen other judgments in previous episodes also, where we have discussed them, that yes, if the claim is received before, after the resolution plan is submitted, then normally the resolution plan is protected by the authorities. On the other side, this 90-day timeline is also important. So my understanding is that for the RP to protect everyone and to minimize litigation, what the RP can do is RP can always make such claims which have been received post 90 days as part of the IM, so that they can also be treated in the resolution plan wherever feasible. So I
And
think this
also,
is
yes, yes.
So I think this is an important step that everyone needs to take. Maybe they can reject the claim received after 90 days, but then maybe they can also communicate to the person who is filing that claim that we are rejecting it because it is time bound, but we are making it part of our IM, and the we will leave it to the resolution applicant to treat your claim as well.
And also, uh, this the notice of the Ministry of Corporate Affairs dated 18th January 2023, it was proposed as one of the amendment that the RP will be authorized to admit claims before the resolution plan is approved by the committee. So, in case we see that, and in case we see this judgment, Ankit, what you are observing is also very important, that the timing of filing of the claim is very important. If the resolution plan is not approved by the committee of creditor, it can still be changed. But once it is approved, I don't think it actually can go back and forth. So that is very important observation, that the resolution plan cannot go back and forth. And the second important observation is that we cannot unleash the hydra-headed monster of undecided claims. And the third very important observation of the Supreme Court is that considering a commercial party. So these three things are very important takeaways of this particular judgment, that it is a RPS is a commercial party. RPS, that means that the RPS is not a home buyer, RPS is not a debenture holder, RPS is not a kind of worker or the. You see, in case we can see, in case like maybe that we we can take up this particular judgment, and then we can take some questions.
Yes.
So we are coming now to Eva Agro Feeds Private Limited versus Punjab National Bank. And in this particular case, the Punjab National Bank, in fact, filed an appeal. So the now let us understand the first of all the issue. The issue is that merely because the liquidator has the discretion of carrying out multiple auctions, it does not necessarily imply that he would abandon or cancel a valid auction, fetching a reasonable price, and opt for another round of auction process with the expectation of a better price. Now, the facts of this case is that the sale notice was issued on 2nd of June 2021 for the sale of assets of the corporate debtor, and 23rd of June 21 was the date fixed for auction of the date. The aforesaid auction date did not materialize, so that the June 21 auction failed. Thereafter, the liquidator issued a similar notice on 28th June 21, within like say 5 days from the last failure, for auction sale again scheduled on 20th of July 21, maybe after about 21 days. Now, in this case, the appellant means Eva Agro Feeds Private Limited was the only sole bidder, and in this bid, uh, the 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 liquidator, in fact, liquidator approved also. The liquidator approved. The appellant paid earnest money deposit of rupees 1 crore. The last date time for submission of bid was 20th of July. However, the bid was submitted 1 day before. It may not be auction. It was not even an e-auction. Had it been an e-auction, it would have been mentioned here, for a sum of rupees 10 crore, which is the reserve price. Now, the appellant received an e-auction certificate from the liquidators certifying that he had won the auction. So this was an e-auction. So how can he submit it before a day? That is not understandable. Because when the e-auction starts on a particular day, only then you can submit the auction. Then the very next day, the appellant received an email from the liquidator informing that the liquidator had cancelled the e-auction and fresh e-auction would be conducted for the subject property. Now, the first of all, the appellant means Eva Agro filed an application before the adjudicating authority NCLT under section 60, wherein the adjudicating authority disposed of the said application by directing the liquidator to send a communication to appellant requiring him to deposit the balance sale consideration within the time specified in the auction notice. Thereafter, the liquidator issued a letter to the appellant to deposit the balance consideration. Pursuant to that said letter, the appellant deposited the entire money on 10th of September 21, following which the liquidator issued a sales certificate also. The sales certificate was also issued dated 15th of September 21 in respect of the subject property in favor of the appellant. Now, while the liquidator accepted the order of the tribunal, one of the financial creditor Punjab National Bank might have been thinking that this auction is not really correct, and they might be thinking that there is a possibility of achieving better. So the Punjab National filed an appeal before the appellate tribunal, before NCLAT, and against the order passed by the adjudicating authority. Now, in this case, the tribunal allowed the appeal filed by Punjab National Bank and set aside the order of adjudicating authority. So this took another 3 months. Consequently, the steps taken pursuant to the said order were also reversed. The liquidator was given liberty to initiate fresh process of the auction. Now the Eva Agro Feed, the bidder, went to Honorable Supreme Court. Now let us see what the Supreme Court says. This decision of the Supreme Court says the apex court restored the order of the adjudicating authority while setting aside the order of the NCLAT. So the observation was the necessary corollary that follows therefrom is that there can be no absolute or unfettered discretion on the part of the liquidator to cancel an auction which is otherwise valid. As it is in an administrative framework governed by rule of law, there can be no absolute or unfettered discretion of the liquidator. Further, upon a thorough analysis of all provisions concerning the liquidator, it is evident that the liquidator is vested with a host of duties, functions, and powers to oversee the liquidation process, in which he is not to act in any adversarial manner while ensuring that the auction process is carried out in accordance with law and to the benefit of all the stakeholders. Merely because the liquidator has the discretion of carrying out multiple auctions, it doesn't necessarily imply that he would abandon or cancel the valid auction, fetching a reasonable price, and opt for another round of auction process with the expectation of a better price. The tribunal had rightly held that there was no objective material before the liquidator to cancel the auction process and no option for the another round of auction. So this is what was the order, Ankit. So we can actually see, we can go to the fourth order of the Honorable Supreme Court. If there is a question, Ankit, we can take the question, or you can even comment on this judgment regarding the liquidator's power. What I feel that if this kind of power is given to liquidators, that they can accept or they can reject any kind of valid auction, that is not something which is good for the profession, and that will raise many fingers on the conduct of the liquidator. The only thing that we have to see is whether the liquidator has followed a process, and as per the regulations, the evaluations were done, the stakeholders' approval has been taken for the reserve price, and if after that the process has been conducted, that is something which is considered to be a valid process, and the liquidator should not have any power to cancel that. Otherwise, the motive of the liquidator would be under question. So this is the basic purpose of this judgment, that the liquidator cannot be given as such kind of. The liquidator is an administrative authority and have to conduct a process according to the process, laid down. He doesn't have a sole power, even if the stakeholder says. Although in this particular case, it has never been covered. What was the stakeholder saying? No, but
Even
in
the
case,
reason for cancellation is not part of the judgment.
yeah,
Then of course we can understand the facts that there is a sole bidder. So in case of a sole bidder, we have seen in multiple auctions previously that anyone who is doing an auction, when he finds that there's a sole bidder, would retract because they would feel that no, maybe the auction has not been properly marketed. That's why people have not come in and participated in the process. So sole participant is something. So whenever we conduct an auction, there are always these terms and the terms and conditions of the auction. And that, in case you write that in case of a sole bidder, in case the auctioneer feels that the is of the opinion that the participants are either there are no participants beyond one person, or there is some kind of a collusion between them, then there is a possibility to cancel the auction. But in this judgment, we don't know the reasons. Maybe the reasons were not properly communicated or not properly brought before the court.
right. So we come to the fourth judgment, and after that, we'll take some questions. Axis Bank Limited versus Narayan Sheth. So this is again a judgment which is important with regard to the limitation aspect. The Supreme Court held in this case that while uploading the condonation of delay in CIRP, while upholding the condonation of delay in CIRP, the apex court observed that the documents being balance sheet and settlement offers relating to acknowledgement claiming benefits of Section 18 of Limitation Act could be accepted even at the appellate stage. So there may be a case that the adjudicating authority must have rejected the commencement of CIRP based on the limitation law, and because since the documents were not submitted there, but now in the appellate stage also these documents can be considered and these documents can be submitted. This is the first thing. However, the main issues which are discussed here, like Section 18, that was earlier also discussed by Honorable Supreme Court in other orders. Now, the effect of acknowledgement in writing, that is what is Section 18 says. Section 18 of the Limitation Act 1963 says, Section 18 actually says the effect of acknowledgement in writing. Now, in this particular case, what this section says, while before the expiration of the prescribed period for a suit of application in respect of any property or right, an acknowledgement of liability in respect of such property or right has been made in writing, signed by the party against whom such property or right is claimed, or by any person through whom he derives his title or liability, a fresh period of limitation shall be computed. A fresh period of limitation shall be computed from the time when the acknowledgement was so signed. Now, in fact, this judgment is clarified in a very clear manner that in case suppose the 3 years are expiring on today, and a day before, in case another acknowledgement comes, then it gets extended for another 3 years. Now, the second paragraph says that where the writing contains the acknowledgement is updated, oral evidence may be given at time when it was signed. But subject to the provisions of the Indian Evidence Act, oral evidence of its content shall not be received. No, the explanation in this particular section 18 only says an acknowledgement may be sufficient, though it omits to specify the exact nature of the property or right, or averse that the time of payment, delivery, performance, enjoyment has not yet come, or is accompanied by a refusal to pay, deliver, perform, permit, or to enjoy, or is coupled with a claim to set off, claim to set off, or is addressed to a person other than a person entitled to the property or right. The word signed means signed either personally or by an agent duly authorized on this behalf. An application for the execution of a decree or order shall not be deemed to be an application in respect of any property or right. Now, the facts in this case was that the State Bank of India declared the corporate debtor Shreem Corporation Limited as an NPA in June 2013. The limitation period would be 3 years from the last date of the financial year before the declaration of NPA, which would be 31st of March 2013 and would run up to 31st of March 2016. Now, there are four major acknowledgement. Now, in case you would see very clearly, 28th June 2013 was declared NPA. That means that the default took place before 31st March 2013 because of that 90 days condition regarding NPA. So therefore, the date has been taken from 31st of March 2013 and not from the date of NPA. Because the date of NPA is a different procedure as per the prudential norms declared by RBI. However, the date of default is something before 31st of March 2013, and the lead period of limitation should have gone to 31st of March 2016, that is 3 years. There are four major acknowledgements made by the corporate debtor after the declaration of NPA and within the expiry of the 3 years from the said date. Now, first of all, the corporate debtor in its balance sheet of the financial year 14-15, which came to an end on 31st of March 2015, had acknowledged the debt in its balance sheet for the said year. Now, this acknowledgement of debt in the balance sheet has been held to be a valid acknowledgement for the benefit of Section 18 of the Limitation Act. From the above date, the period of limitation would run up to 31st of March 2018. So, 31st March, normal 3 year elapses on 31st of March, June 2016, 3 years. Now, in the financial year 31st of March 2015, the acknowledgement was done in the balance sheet. So this gets extended up to 31st of March 2018, and thereafter, before 31st March of 2018, an OTS proposal dated 16th March 2017 was submitted. And then the 3 years starts from 16th March 2017. Another OTS proposal was submitted on 1st January 2018. Then another 3 years started, and the third OTS proposal was submitted on 16th May 2019, and another 3 years started. Now, in this case, the last date of acknowledgement was 16th May 2019, and the date of filing of the Section 7 application was 22nd of January 2020. That is within say 7-8 months of the last acknowledgement. That is very well within 3 years from the date of the first, second, and the third OTS. Therefore, the application under Section 5 of the Limitation Act was also filed along with the petition for condoning delay of 1392 days. Later on, an additional affidavit was filed stating that the delay was only of 662 days in view of the acknowledgement in the balance sheet of the corporate debtor for the financial year ending 31st of March 2015. Now, the adjudicating condoned the delay of 662 days and passed an order of admission appointment of IRP. The appellant preferred an appeal before NCLAT under Section 61. The NCLAT, then finally, it went to the Supreme Court. And NCLAT dismissed that was dismissed by the NCLAT. Now, the kind of appointment the adjudicating authority condoned, and the CIRP commenced, and finally it had actually gone to Supreme Court. The Supreme Court observed the Section 3, subsection 1 of the Limitation Act creates bar on the institution of any suit, appeal, or application made after the prescribed period of limitation to be dismissed, even though limitation has not been set up as a defense. Section 5 of the Limitation Act provides for an extension for the prescribed period in certain cases where sufficient cause or for not preferring the appeal or where the application could not be made within the prescribed time. Section 18 of the Limitation Act provides that where acknowledgement in writing of the liability is made by a party against whom any right is claimed, a fresh period of limitation shall be computed from the time when the acknowledgement is so signed. A plain reading of Section 18, subsection 1 of the Limitation Act would reflect that where any acknowledgement of a liability has been made in writing by the party against whom any right is claimed, a fresh period of limitation would be computed from the time when the acknowledgement was so signed, subject to such acknowledgement, subject to such acknowledgement made before the expiry of the prescribed period of filing a suit or an application in respect. Now, finally, the Section 18(2) of the Limitation Act may not be applicable in the present case, since all the acknowledgements in the present case have a date, and therefore there would be no question of needing any oral evidence to establish the date of the acknowledgement. After considering the facts, the final Supreme Court said that the secured creditor would definitely have a right to invoke the power under the SARFAESI Act, and the said proceedings cannot be said to be without jurisdiction. The documents relating to acknowledgement claiming the benefit of Section 18 were introduced at appellate stage, and such documents being balance sheets and the settlement offers, it was held that the same would be accepted even at the appellate stage, and a settlement offer akin to an OTS proposal would be an acknowledgement of debt for the purpose of Section 18 of the Limitation Act. The balance sheet acknowledging debt is also a document relevant for calculating the limitation. The acknowledgement should be made within expiry of the limitation period of law. On this point, it has been factually found that taking the date of acknowledgement of debt in balance sheet and the three OTS proposals, the same were within the limitation under the law or extended timeline due to acknowledgements. So therefore, the Supreme Court, Honorable Supreme Court said that the NCLAT order was absolutely correct, and the limitation is not applicable. Acknowledgement actually is getting extended. So therefore, the CIRP of this company would be valid.
So
Yes.
in a nutshell, any acknowledgement would further the limitation period, which can be OTS settlement proposals, it can be some kind of a acceptance, some kind of a confirmation, it can be, many things. So I think that's something that many would be able to use to extend the limitation period wherever, such acknowledgements are available. We have 10 more minutes. We can, rather than
Take
going
up some questions.
questions I have already answered. I have only one question with respect to the limitation part, which is limitation applicable to claims too? Can RP take a decision not to admit the claim due to limitation? So the claim admittance is not as we said before, is not a it is not something that you have to say that, okay, which is payable or not payable due to limitation period. But I believe that the claim is a claim, and it has to be admitted in case it is submitted within 90 days. I don't think we need to use Limitation Act to see if any claim needs to be admitted or rejected. Maybe you can confirm
I
that.
think the RP can take a decision regarding the applicability of limitation law on the claims. But since the limitation law is something which needs adjudication, it is not automatic. So therefore, RP it should not become a kind of adjudicating authority in this case regarding the. So then RP should say that like I'm not admitting because of the limitation. Then the other person will go to the court. So the
Yeah.
court will say that like as far as the disputed can be accepted, but there is no word in the definition of claim that even the so RP can take a call if it is a very clear-cut case of time barred or limitation barred claims. RP can reject it,
So let's
and then the other person will go
quickly,
and file an
yeah.
appeal.
So we have 9 more minutes. We can maybe quickly talk about the NCLAT judgments and the kind of judgment that has been passed. Rather than going through the entire judgment, we can try and wrap up in 10 minutes if there are not too many judgments. Or you
I think
want?
this is also very important. Like again, the commissioner Uttar Pradesh GST department judgment. So in case you would see this judgment, so this is the again a judgment where the it was held by NCLAT that after extended period of 90 days of the insolvency commencement date, the RP is not obliged to accept the claims. Now the facts of in this case is like in the case of Radha Madhav Corporation Limited, which The CIRP commenced on 22nd of October 2020. The last date for filing of the claim was 25th of November 20. 90 days extended period therefore extended on 24th of February 21. RP informed of the Deputy Commissioner Uttar Pradesh GST and UT Union Territory, Union Territory their claim in Form V. Now, the Union Territory GST submitted their claim on 9th of November 2021. These claims were rejected by the RP on 3rd December on the ground being belated, following which the UT GST filed appeal before the authority seeking to get their claim admitted. The uh, the GST department submitted their claim in form on 2nd of November relating to the penalty imposed on the corporator amounting to 37 crores. These claims were happy on the grounds of delay. The seeking the get the resolution plan of VAMA was approved on 20th of February 2021. Now, in this case also, you probably see the claim when the claim was being filed, Form B was in November 21, and the resolution plan was in fact approved within almost 1 month, 18 days. So that means when these plans were almost at advanced stage, and the COC approved it in 15th meeting. So the RP, the RP preferred an application before the adjudication authorities seeking the approval of the resolution plan. So that was also pending. So when this particular application of GST basically heard, but it was being heard by the adjudicating authority at that time, the approved resolution plan approved from COC before the adjudicating authority. Arise whether on account of the rejection by RP of the claim filed by the UTGS, the CGST, the resolution plan of VAMA as approved by the adjudicating authority does not meet the requirement under the applicable law. From a plain reading of the Regulation 12, RP can accept the claim as per the extended period as provided in Regulation 12 sub Regulation 2. Now, the entire regulation is read here. Entire in the regulation, it is saying that the or on or before the last date for mention in the public announcement, or maximum 90 days. So that's what the Regulation 12 of CIRP regulation says. And after extending period of 90 days of the insolvency commencement date, the RP is not obliged to accept the claim. This was the observation of the NCLAT. Prima facie, the said CIRP regulation has not provided any discretion to RP for admitting their claim after the extended period. So there is no power, there is no discretion. Had they submitted their respective claims within the extended framework and the RP had not chosen to collate this claim as provided for the RP, only then can it be rightly contended that there has occurred some material irregularity. In the instant case, the fact on the record do not in any manner show that the RP was not diligent in performing his duty or acted in contravention of the IBC in rejecting the belated claims. Now, this tribunal is further saying that this tribunal, while applying its judicial mind in exercise of the appellate jurisdiction, cannot be oblivious of the fact that the CIRP is a time-bound process. Therefore, when a resolution plan has already been received and approved by the COC, we are inclined to agree that if the claim of the creditors are accepted at a belated stage after the stipulated time period for submitting claims, then the possibility of resolution plan failing to materialize becomes very high and tantamounts to defeat the objectives of the IBC. It again actually forth and back and forth, chalta rahega. So the logic here also in this NCLAT judgment is also like once the resolution plan is approved by the committee of creditors, then admitting claims is not really fulfills the objective. The time-bound process would not be fulfilled. So I also remember, Ankit, a judgment which actually came in the last week only. And that judgment was very clear regarding the PF dues. So the Department of Provident Fund, in fact, submitted their claim, related claim, and finally it went up to Supreme Court, and Supreme Court said that the claims must be filed on time by the Provident Fund Department. So even the Supreme Court said that any officer of the department who has not submitted their claim on time should be fined 5 lakhs of rupees. So that particular judgment is also very, very strength. So today we actually are saying that the judgments, one, we have seen the judgment of a commercial entity. Second, we have seen a judgment. Again, this is a kind of claim from the CGST department. So one, we have seen the claim of a CGST, it means government agency. One we have seen from a corporate, so from a commercial entity, and now we also recall that we have seen the claims of the Provident Fund department, that again some of the statutory authority. So all these claims can be rejected. However, all these judgments should not be applicable directly and in spirit to the claims of home buyers and other such people. So, Ankit, what we are now trying to say is that this is something which is IBC would be slightly comfortable, the RPs would be slightly comfortable, but this may increase litigation because anyone who actually gets delayed, I would still say that the RP can say by mentioning the reasons, by taking it to the COC, that if we will accept this claim, that actually will be a natural justice. But in case we do not accept the claims, then it would be a kind of litigation. So with that kind of approach, the RP can go to COC and discuss and deliberate what action can be taken regarding admitting or rejecting a claim. So this is what is all about today, Ankit. In case there is any question, we can take up, and the otherwise we can conclude, or we can take up one more judgment.
So one question, Lalit Maheshwari is asking that when both parties approach an arbitration after limitation period, can limitation period be applicable with respect to initiation of CIP proceedings? So my understanding is that if there's an arbitration proceedings that have started and that arbitration award is given to one of the parties, that is the time from which the limitation period for CIP or IBC should commence. Maybe you can
But I think
also.
Lalit Maheshwari is saying that both the parties have gone to arbitration for a
Yeah.
time barred debt.
Hmm.
That itself shows that they are acknowledging.
Yes.
So if they are acknowledging the debt, and they want to have an arbitration award on that, I think if the both parties agree, then they can forget about the limitation part of the
Yeah.
entire proceedings. They can do that. Any other question, Ankit?
That's about it. There's another question, and that question is from Anil Sharma ji. He's asking if Supreme Court is saying no claim can be accepted after RP is approved by or resolution plan is approved by COC, then doesn't it contradict Regulation 12?
The regulation 12 says 12, 90 days, nothing was. But in case the regulation would be amended, as we have seen the notice of Ministry of Corporate Affairs on 18th of January 2023, that it might even get a modification in the regulation or in the law that the RP can accept claims up to the date of approval of the Committee of Creditor approval on the resolution plan. So, however, this is not contravening as of today. As of today, the regulation 12 says that the RP 90 days is the extended period. So, up to the
Yeah.
90 days, the RP has the discretion, but it doesn't have power to reject one and accept others. 90 days is 90 days. If up to 90 days, the RB should accept it if found in order.
Right. So that's about it. That's the questions that we had.
So I think great 1 hour is actually very short, and we actually feel like continuing our discussion with all of you. We also feel like deliberating of all whatever we have prepared. But the time is important, so we would like to close it within 1 hour. Thank you very much again. Congratulating to all of you on 75th episode of AAA Weekly Webinar Series. Thank you very much. Have a good day.
Thank you. Thank you for motivating all of us. Thank you.